One of the reasons I decided to teach people 8 years ago, start teaching classes around the country, I would go to different trials and observe people going to prison for things like willful failure to file tax returns. And I used to wonder, why can you go to jail for not doing something? How can that be? You don't do something and you go to jail for it. That doesn't sound right to me. I see all these arguments that they would be making, these patriot-type arguments, and they were absolutely off the wall. The judges would, rightfully so, get very upset with them because they're disrupting the court. They have no basis in law or argument, and they wind up going to jail. So I said, the reasons are they're half right. If you're half right, or if you're 99% right and you're defusing a bomb, what's the result? You're still dead. And that's when law. It's very exacting. You can't be almost right. Horseshoes and hand grenades is okay, not in law. So I decided to make it my life work until I retire or die, to educate people in the proper application of the law and how to use the rules in their favor, to go into court and have some confidence that they have an opportunity to win. I'm convinced in almost any action, whether it be foreclosure action on your home, whether it be a bank action on credit card debt, or any other civil action at all, if you're a defendant, you probably lost already. Whenever you discover fraud, for instance, in the banking industry, we know that it's full of fraud. It's just full of fraud. And those of you who don't know, I'm sure PQI will educate you on that fraud. The moment you find out you've been defrauded, your proper course of action should be to take those charges to the proper court and seek a remedy as a plaintiff in the action. And you should be furious if somebody has stolen from you. And that's what the banks have done. They've stolen from you. So if you become the plaintiff in the action in the proper venue, now the state courts, in my opinion, would not be the proper venue because most state judges their elections are supported by banks. Majority of their campaigns funds are given by banks. So I suggest at that point there, because they owe a favor to the banks, they're not going to readily rule in your favor in state court. So it's a stacked deck. The moment you find out you've been defrauded, and once you learn that, properly so, you should go to federal court as a plaintiff in the action, in the federal court, away from the state judges, because it's a federal question. The Banking Act of 1933, another case, Elmira v. Davis, where the Supreme Court said that all banks, national banks, are instrumentalities of Congress. It's a federal question then. At that point there, congressional law overrides and has precedence over state law. It's a federal question. The judges have a right to take jurisdiction in that case. If it's a federal question and you have their charter showing what powers that they have, the powers of a bank is located in this charter. All corporations, their powers are listed there. If a bank, does it have a right to loan credit? The answer is no. No state or federal bank has given that power. Can it charge interest or usury on that money, on the credit that it loans? No, it cannot. Since the charter does not give it the right to charge interest on credit and to loan credit at all, then the contract itself is what's called ultra verus. The doctrine of ultra verus means that it's illegal from the beginning. Therefore, the contract you entered into on a loan agreement, whether it be for credit cards or for foreclosure, are in fact void. So if you go to court as a plaintiff in the action and you file your complaint, after 20 days, you would file a motion for summary judgment. Your evidence would be the bank charter and your contract. And at that point there, you would make a motion for summary judgment as a matter of law. The judge cannot rule in their favor at all because it's an illegal contract. You cannot award them anything. You must prevail.
So based on what you've just said, it appears to me that the optimum way to go into court is knowing in advance that you've already won, because you know what the responses and the steps and the answers and the questions will have to be, so that, as you say, the judge has no choice but to rule in your favor. So this is a little bit like being a chess master. You can see several moves ahead on the chessboard, and the other player is only thinking in terms of the next choices of the next move. They have a few options, but you know for every one of those options, the 4 or 5 steps beyond. So that's how you win in court. It really is like a chess game. But let's say, as you said, that after your birth, there's the certificate of live birth, which is not your birth certificate, but it's a statement from the hospital that, yes, you were actually born and your name is written normally with capital and lowercase letters.
That's correct.
And then there's some deal which you don't know about, which ends up as a birth certificate, which is a state document. And that's the capital letters that puts you as a fictitious person like a corporation. And then for the rest of your life, you think they mean you when they send you something that's all in capital letters. But in fact, it isn't you. It's a corporation that is a front for you, or a substitute, an alter ego, as it were, or the straw man. Now, since you didn't know about this, since you were only a day old when this whole thing happened, and then it continues on through your eventually getting the Social Security number and opening the bank accounts and registering to vote, and you still are completely unaware that every time you do this, you're creating a contract, and you're stuck to those contracts, which is why they're called adhesion contracts. Mm-hmm. you are already not yourself when you step into court.